The sun shines through concertina wire on a fence at the Louisiana State Penitentiary in Angola, La. Nearly 2 years after the January 2016 U.S. Supreme Court ruling that prison inmates who killed as teenagers are capable of change and may deserve eventual freedom, the question remains unresolved: which ones should get a second chance? Photo, Gerald Herbert/AP. Nearly 2 years after the U.S. Supreme Court ruled that prison inmates who killed as teenagers are capable of change and may deserve eventual freedom, the question remains unresolved: which ones should get a second chance? Now the ruling, which came in the case of a 71-year-old Louisiana inmate still awaiting a parole hearing, is being tested again in that same state, where prosecutors have moved in recent months to keep about 1 in 3 former juvenile offenders locked up for the rest of their lives. There is no possible way to square these numbers with the directive of the Supreme Court, said Jill Pasquarella, supervising attorney with the Louisiana Center for Children's Rights, which found that district attorneys are seeking to deny parole eligibility to 84 of 255 juvenile life inmates whose cases are up for review. Some prosecutors countered that the heinousness of some of the crimes makes these inmates the rare teen offenders the court said could still be punished with life behind bars. In this community, some of the most violent crimes we've had have been committed by juveniles, said Ricky Babin, district attorney for Assumption and St. James parishes, who has filed motions seeking new life without parole sentences in 4 of 5 cases. The moves by Louisiana prosecutors echo the aggressive approach in Michigan, where district attorneys are seeking to keep 2/3 of 363 juvenile life inmates behind bars for good. That state's cases have been on hold for months now, awaiting a ruling on whether judges or juries should decide them. The friction prompts agreement by prosecutors and advocates that the nation's highest court likely needs to step back into the debate over how the U.S. punishes juvenile offenders. It's definitely clear now that the court does need to clarify that life without parole is unconstitutional for all children, said Jody Kent-Lavie, director of the Campaign for the Fair Sentencing of Youth. We've seen in certain states, in certain jurisdictions, that the standard that was set by the court is one that prosecutors and judges don't necessarily feel compelled to follow. The court's January 2016 ruling extended a ban on mandatory life without parole for juvenile offenders to those already in prison for murders committed when they were under 18. The decision didn't lay out specific procedures for states to follow in reviewing the cases of those 2,000+ inmates nationwide. Rather, it said only that a lifetime behind bars should be reserved for the rarest offenders whose crimes reflect irreparable corruption. The court cited research showing the brains of adolescents are still developing, and found that punishing teens with the same severity as adults is cruel and unusual and fails to account for the differences of youth or the potential for rehabilitation. The decision ushered in a wave of new sentences and the release of dozens of inmates in states from Pennsylvania to Michigan, Arkansas, and beyond, but also brought confusion and inconsistent approaches in other states, an Associated Press investigation earlier this year found.